Your Honor, he would still like to go through with the hearing.
All right. Mr. Siller, are you ready to go forth on this?
We are ready, Your Honor.
You may proceed.
Your Honor, at this time, I would call Mr. Casey, Brandon Casey, from the Washington County Sheriff's Office.
Sir, if you could please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
I do.
All right. Thank you. State your name, please.
Brandon Casey.
All right. Thank you. Go ahead, Mr. Siller.
And Mr.
You can
Casey,
have a seat.
Mr. Casey, you're a supervision agent at the Washington County Sheriff's Office. Is that right?
Yes, sir.
And when did you start there?
Oh gosh, 2019.
2019. All right. And as the supervision agent, what are your general duties?
My general duties are to place people on scram tethers, sober links, and GPS, supervise them under pretrial services and probation.
And you've been doing that since 2019?
Yes.
Are you familiar with Martell Williams?
Yes.
And is Martell Williams someone that you supervise?
Yes.
When did you begin supervising Martell Williams?
His enrollment date was November 1st of 2023.
And at some point, you became aware of Mr. Williams was placed on a scram tether. Is that right?
Yes.
And was that on February 7th?
Yes.
February 7th of 2024?
Yes.
After February 7th of 2024, did you become aware of a violation of that scram tether?
Yes.
And what was the date of the first violation?
I received the first violation on February 15th, but it was dated for February 10th and 11th.
And so you said you received it on the 15th. Why is that? When the violation was earlier, why did you not receive it at that earlier date?
Typically when there's a pending result, AMS has to figure out whether it's a confirmed event or not. And then once it's confirmed, they forward me the non-compliance report.
Okay. And there was a second violation. Is that right, of the scram tether?
Yes.
And what date was that second violation?
I received that second violation, I believe, on February 26th, but it was dated for the 16th and 17th of February.
Okay. And once again, that's for the same reason that you were notified of it later, or you had to download the information?
Yeah, there was also a point where he had went quite a few days, several days, I believe, until he came in for his next download. That's why it took so long.
Did you have any conversations with Mr. Williams regarding these violations?
Yeah, when we have the non-compliance reports, we typically call the clients, let them know what's going on. He said he was concerned about some of his hygiene products.
Okay. And what do you do with that information? You then forward that information to the court, is that right?
Yes.
Okay. I don't have any further questions for Mr. Casey. The defense counsel may have a question.
Go ahead.
Mr. Casey, you did testify that you started his supervision November 1st of 2023,
Yes.
and he was at first placed on a sober link tether, correct?
Yes, that's correct.
Did he ever receive any positive tests while on that sober link tether?
No positive tests, no, just missed or late tests.
And on February 7th, 2024, he was placed on the scram tether.
Yes.
Okay. On February 15th, you got the notification that there was a missed test or a positive test for February 10th. Is that correct?
Yes.
Now, usually it is your practice that you guys would call the client and inform them that they can take a urine test to double check if there is alcohol in the system. Is that correct?
If it's within the 3-day period for the ETG, yes, that's correct.
And this was outside the 3-day period, correct?
Yes, that's correct.
So he was unable to take the urine test?
Correct.
Okay. And then the February 17th event, similar, you weren't aware of this until February 26th. Is that correct?
Yes,
So again, Mr. Williams did not have the opportunity to take the urine test. Is that correct?
yes.
And do you think that the urine tests are more accurate than the scram tethers?
Um, I don't believe so.
Is there ever a time when a scram tether would come up positive and then a urine test would come back as negative?
I haven't experienced that yet in the past, no.
Okay, no further questions, Your Honor.
All right, thank you. Any other follow-up, Mr. Siller?
Just Mr. Casey, can you see whether Mr. Williams is in the courtroom or not? Are you able to tell that?
Yeah, I can see him.
Can you identify him for the court?
I believe he's wearing a black hoodie. And I want to say his shirt is purple, but I can.
All right, without objection, record will reflect identification of Mr. Williams.
Thank you. No further questions for Mr. Casey.
All right, thank you. Do you have another witness?
We do, Your Honor. I have John Hayes from Judicial Services Group.
All right, sir, if you could please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God? And you'll need to unmute.
I do, Your Honor.
All right, very good. State your name for the record, please.
John Hayes.
All right. Go ahead, Mr. Siller.
Mr. Hayes, you're with JSG, is that right?
Correct.
And is that Judicial Services Group?
Yes.
And that does monitoring for persons under the order of the court, is that right?
Correct.
And included in that monitoring is scram tether monitoring, is that right?
Yes.
And are you familiar with the case involving Martell Williams?
I am.
Mr. Williams had at least 2 positive scram teller violations, is that right?
Yes.
How long have you been with JSG?
Approximately 11 years.
And during that time, you're aware of studies involving ways to detect external alcohol, the presence of external alcohol, is that right?
Correct. In regards to the scram in my history, I have attended numerous trainings. I've lectured all across the country for different agencies. I've testified in over 450 cases, been entered as an expert in 32 cases regarding the device. I've done quite a bit of research, attended conferences in this exact regard, so yes.
You said you've been qualified as an expert in courts.
Correct. 32 times, including in Washtenaw County, both district and circuit courts.
Okay. Do you have any educational background that would be relevant to this?
Education-wise, as far as schooling, no. However, I've attended multiple trainings, the most recent being Indiana University Borkenstein course on alcohol, which is over 100 of the top toxicologists in the world. So education-wise, no. Continuous training, yes.
Your Honor, I'm going to move to qualify Mr. Hayes as an expert in the scram tether, use of the scram tether.
Any objection or voir dire?
No objection.
You're so qualified.
Mr. Hayes, tell us about some of the studies that you've been involved personally regarding personal hygiene products that may contain alcohol and how that may affect a scram tether.
There's quite a few. Obviously, I was present earlier when the concept of hair products, conditioner, shampoo, I believe hair wax had been brought up. The most applicable study is one that was presented during COVID regarding ethanol-based products, specifically hand sanitizer. What they were focusing on is if you are applying hand sanitizer in excessive amounts, how quickly your body could absorb that alcohol and what it would do similar to consuming alcohol. The conclusion of that report is someone who applies hand sanitizer, which is a very high level of ethanol, every 30 minutes for 24 hours straight. So 48 applications, the body would absorb approximately 0.2 grams of alcohol. It's important to note that a standard drink has 14 grams of alcohol. So Bud Light has 14 grams. Doing the application, it's 0.2 grams, far less than 1% of a standard drink. So any product similar to that, if it's stated that it would be absorbed through the skin, it's extremely improbable to reach a very low level, reach a 0.03 or higher.
So what you're telling the court is that on a standard one can of beer, like such as Bud Light, would have 7 times the amount of alcohol than the lotion?
Not 17. You're talking, math is not my specialty. I'd say 80 to 90 times more.
Okay.
But it's also important. I've worn the device over 100 times. I've used products that contain alcohol, lotions, hand sanitizers, not just on my body, but directly on the bracelet. And it's important to note, even when you do that, the device knows, one, that it's an external alcohol, and two, as soon as that product evaporates, if you put hand sanitizer on your hand, it dries off within minutes. It's not going to continue to stay there, let alone absorb and eliminate, similar to what we know alcohol does with the body.
You said that hand sanitizer has a higher concentration of alcohol than a hair product. Is that correct?
Correct.
Do you know of any specific studies either you've done or that you've heard about or read about regarding hair products as opposed to lotion, hand lotion?
No, I have not. Hair products in particular, no.
And what is now a lotion would have alcohol that's applied onto the skin itself. What's the significance of that as opposed to how the scram tether is designed to detect the ingestion of alcohol?
So the scram device knows the difference between consumed alcohol and environmental alcohol. The way it does that is prior to testing the sample taken from the client, it takes a sample from the environment. If it's something, we have people who work in bars, we have people who work in bakeries who wear the scram without incident because we can see that the alcohol we're seeing is coming from the environment. One of the criteria that we use to identify confirmed consumption is that the event must pass the environmental contaminant test, which tells us if there's alcohol present, it's coming from the sample from the client and not the environment. And I did look back over the entire duration that Mr. Williams has been on scram, which as of today has been 64 days. There were 0 issues on any other day with the exception of these 2 dates.
You're familiar with the transdermal alcohol consumption reading of Mr. Williams's 2 violations, is that right?
I am.
And do you have that information in front of you?
I do.
On the violation of February 11th, 2024, he had a peak transdermal alcohol concentration of 0.39%. Is that right?
0.039, yes.
0.039. All right. I wrote that down incorrectly. You are correct. I'm incorrect. Are you able to give the court any relevant information about how would that alcohol concentration level be achieved through the use of an external product of lotion, of hand lotion, which you seem to be more familiar with?
Yeah, hand lotion or any external product used on the skin or around the device to simulate what we're looking at on a confirmed consumption event. Let's say that alcohol is in the lotion. In order to recreate the graph and the data that we have, you would have to gradually increase the usage every half hour of that lotion and reapply it. When you put lotion on your hands, it dries out within a couple minutes. You'd have to continuously apply it to the area or to your skin, and then gradually decrease it in a way that mirrors what we know the body does with alcohol. It gradually absorbs alcohol and then gradually decreases it. So in a case like this, it begins at 6:40 p.m. and doesn't reach zero again until 6:09 p.m. the next day. For 24 hours, you would have to increase it for approximately 8 to 10 hours, and then gradually decrease it for the next 16 hours. It's not one application and your body's absorbing and eliminating it. It's continuous use.
So what you're saying is using an external product, like lotion, you'd have to use the product for perhaps 24 hours or more to achieve these types of results?
You'd have to continually apply it. One of the studies that I did was for colognes and aerosol sprays. And without reapplying it continuously, the next test would read a result of 0 because it's no longer present.
And that's regarding the scram tether violation on February 11th. Would that same analysis be consistent with the scram tether violation of February 17th?
Yes.
And it's a similar number. It's 0.033 was the peak transdermal alcohol concentration. Is that right?
Correct.
And to achieve that peak transdermal alcohol concentration, he'd have to have used an external product for, perhaps 24 hours, 24 hours or so. Is that right?
This one's a little bit shorter. It begins on February 16th at 10:08 p.m. and returns back to 0 at 2:57 p.m. on the 17th. So a shorter duration. However, yes, but it's also important to note the theory of applying a lotion or anything is categorically false. I've tried to recreate it myself dozens of times and never been able to even closely do that. This is definitely a confirmed consumption event on both cases.
I don't have any further questions for Mr. Hayes. I'm sure the defense counsel will have a question or more.
Ms. Coombs, cross-examination.
Mr. Hayes, you testify that you do work for Scram Tether, correct?
We provide scram tethers. I do not work for them directly.
Okay. All right. Would you agree that you have an interest in making sure these tethers do work correctly?
Somewhat.
Okay. And you previously testified that you have testified in other court cases over 450 times. Is that correct?
Correct.
You have testified over 450 times in other cases?
Yes, in my career over 450 times.
And how many times have you tested on behalf of prosecution?
I'd say the majority of them.
Okay. What is the error margin for Scram tethers?
I'm not aware of that, but if it's a singular result, I believe it's somewhere south of 3%, but in totality, multiple events, they found 0 false positives because you're not just reviewing one single point, you're reviewing dozens and dozens of test results to confirm a consumption event.
Okay. And what is the average elimination rate per hour for ethyl alcohol?
There is no average. There are 4 different settings or 4 different categories that have been identified on breath alcohol. However, there's never been a summary of transdermal alcohol, as it is generally much slower than what breath alcohol is.
Okay. And you previously testified that there are no studies in regards to hair products and how they could affect a positive read on a Scram tether. Is that correct?
I didn't say there isn't any. I'm just not aware of any.
Okay. On February 11th, 2024, there was a peak of 0.039 at 3.
In this gripping and fast-paced courtroom session, Judge Simpson handles a series of back-to-back cases ranging from a heartwarming redemption story to a jaw-dropping bond revocation that sends shockwaves through the entire courtroom. The session opens with Miss Pointer, who appears for a bond review after previously testing positive for cocaine while out on bond for a serious drug case, but arrives this time with genuinely impressive documentation. A letter from Dawn Farm confirming she completed their intensive outpatient program, clean drug tests, steady employment, and a recommendation from her probation officer that she be released. Judge Simpson reviews everything carefully and releases her on a personal recognizance bond with continued drug testing, telling her warmly that he hopes the next time he sees her it is for something positive rather than another court hearing. The second case involves Mr. Hawkins, who is seeking bond reduction on a home invasion charge. But his attorney immediately hits a wall when Judge Simpson reveals he has been reviewing Hawkins' jail phone calls and discovered something deeply troubling. Hawkins has been calling a woman who appears to be connected to his case and making statements that could constitute witness tampering. The attorney asks for time to review the calls himself before responding, and Judge Simpson grants a brief recess. But when the hearing resumes, the prosecution reveals the full picture. Not only are the calls potentially tampering with a witness, but Hawkins violated his bond conditions by making contact with someone he was specifically ordered not to contact. Judge Simpson denies the bond reduction entirely and actually raises serious questions about whether the bond should be revoked altogether, ordering the prosecution to file a formal motion if they believe revocation is warranted. The most dramatic moment of the entire session comes in the third case when a defendant named Mr. Cross appears via video from